Please be seated. Good morning. Welcome to the Kansas Court of Appeals. My name is Lori Bolton Fleming. I'll be your presiding judge for this docket. I'd like to start this morning by introducing your panel. To my right is Judge Stephen Hill. Judge Hill grew up in Wichita, but spent most of his legal career as a lawyer, county attorney, and judge in the 6th Judicial District in Southeast Kansas. He joined the Kansas Court of Appeals in 2003. Having served 22 years as a district judge, he was first appointed to the bench in 1981. To my left is Judge Catherine Gardner. Judge Gardner was appointed to the Kansas Court of Appeals in 2015. Prior to joining the court, she served as a research attorney on the Court of Appeals, a law clerk for a federal judge, an assistant attorney general for the state of Kansas, and as a litigator in private practice. And as for me, I joined the court in 2025 after serving as the chief judge of the 11th Judicial District in Southeast Kansas, which is comprised of Cherokee, Crawford, and Labette counties. I was a district judge for 13 years, and prior to that, worked in private practice and a prosecutor. So we have 2 cases set on today's docket. Before we get started, I would like to thank a few people. We have a lot of research attorneys. We have staff members that made today possible. We have people that are making it possible to view this hearing online. So we thank you for your efforts. And I also want to say good morning to a few interns, law students, and pre-law students who are joining us today. We welcome you to our court. So at this time, I will call the first case on the docket. This is Brian Paul Kelly and Catherine Lynn Ferguson, trustees of the Paul Wayne Kelly Trust, and Catherine Lynn Ferguson, individually appellees, Bilaco Holdings, LLC, a limited liability company appellant, a case out of Cowley County, Kansas, case number 128610. Would counsel for appellant please enter your appearances?
Chris Steinkamp with Pugh, Gillen, Rathbun, and McIntyre for appellant Lawco, and I have Aaron Lawson, the Chief Operating Officer of Lawco, at the table with you.
Thank you. And for appellee?
Thomas Rhodes, Your Honor, Wichita, Kansas. On behalf of the appellees, the plaintiffs in the district court case.
Very good. Thank you. And so I think we will pause here to just review our procedure. I think most of you are familiar with this, but each side will receive 15 minutes for oral argument. The appellant is allowed to reserve a portion of that time for rebuttal. Would the appellant like to reserve?
If I could, 5 minutes.
That is granted, and our timer will set the clock accordingly. So 5 minutes, there we go. Perfect. All right, counsel for appellant may begin.
May it please the court. First, I want to thank you all for adjusting your docket at my request to accommodate my schedule. So I appreciate your courtesy in that regard. This matter arose out of, I think, a little bit of perhaps misunderstanding and perhaps some sour grapes on behalf of the plaintiffs. The lease that is at issue here was signed by the current plaintiff's parents, Paul and Diane Kelly, and was given to Lawco's predecessor in interest as well.
Counsel, we're familiar with the facts. Let's get right to it.
Okay.
You don't have much time. You've got 10 minutes to convince us why the district judge was wrong. So how did the judge get it wrong?
Okay. The district judge, first of all, there are really a couple of issues. One is whether or not this oil and gas lease is producing and paying quantities. Lawco's drilled 3 wells on this property that have been producing oil since about 2014.
Now, this is a unitized lease.
It is.
There's been no wells drilled on their lease, but because it's unitized, it's included in the group, correct?
Correct.
So
The
when you
effect-
say there's wells have been drilled, you don't mean on their lease, but you mean on the unit.
On the unit, correct, Your Honor. And the unitization, the effect of that is to treat all of the leases that are unitized as if they are one lease.
And so by proportion, they got, now.
Right.
The problem, it seems to me, when I read your briefs, is the year 2020.
That has been an issue, Your Honor.
Well, tell me, how much oil did you produce on the unit in 2020?
The oil was produced approximately equal to the amount that was produced in the prior year and the subsequent year. It was not sold. And the reason it wasn't sold is, as you may recall, in 2020, the world was shut down, including all of the courts, from March of 2020 until about March of 2021. Lawco had a tank that is approximately twice the size of what you might typically find in that area of the world on this lease, because one of the wells that's drilled there is a horizontal well and it produces a lot of fluid. So Lawco was able to store the oil in that tank for the year of 2020, even though they were producing it out of the ground, and they sold it in 2021. The data for that is in the court file and is in front of the court.
But I
And the
think
volume is
just-
about twice.
Just to pause for a second. So I
Sure.
think the Applebee's position on that point is the quality of oil that was sold in 2021 doesn't really reflect that it was their oil because it was of a lesser quality. Can you address that point?
I can. Actually, I don't believe it was of a lesser quality. What it was is that the purchaser, Coffeyville Resources, which is relatively local down there, has a policy that they don't take oil that's been in the tank over a year. And so it was sold to a reclaimer, but in the court records, there is a breakdown of the oil, which is very typical of the oil that was produced before and after it. It only has about 3% of fines and water and different things like that, which is typical of normal oil production. So there really isn't a quality difference. The plaintiffs have made a point of trying to argue that, but they don't really have any evidence that supports that, because the evidence from the purchaser is that it's typical of normal oil.
Well, the heart of this case, isn't it, that the reason why this lease is going on is because the primary terms expired and now it has to be produced in paying quantities for the habendum clause to be operable. Is that correct?
That is correct. It is in the secondary term, Your Honor.
And because of that, the question is, has there been paying quantities? And the district court said no.
Well, interestingly, the district court calculated that it did, in fact, even with the district court's calculation, make $19,000 over the period of time that the district court determined was appropriate, which was from 2016 to 2022. Now, the math from Lawco is it made about $45,000 for the period of time that it's been operated. The district court did not consider the first year of operation, 2015, but the calculations are specifically that it made income of $62,105.13 and had expenses of $42,879.64.
And what did what kind of royalties did the plaintiffs receive?
Well, the plaintiffs were paid royalty based on their proportion, which is, I believe, the piece of the unit that is the lessors are entitled to is, I believe, about a quarter of the total amount of royalty. And once
So can you
the
answer my question? How much did they receive?
dollars,
Yeah.
I don't know, Your Honor. I believe probably about, I'm not sure. Do you know?
Your folks paid them. I mean,
Well, actually,
Your
my
fa-
folks did not pay them. The purchaser pays them. Coffeyville Resources pays them. And one of the things that started this was that they didn't update the records with the purchaser. And so the purchaser put their interest in suspense. And so there was money in suspense that they hadn't been paid, and they thought they weren't making any money at all. When in fact, once they updated the records, once Paul and Diane Kelly had transferred it to this trust. That
now,
the
when you
fees-
say they didn't update their records, to
the-
whom were
the
you referring?
plaintiffs. The oil and gas lease at the bottom of the first page, and these are not numbered paragraphs, unfortunately, but the oil and gas lease puts the burden on the lessors to maintain current addresses and title information with the oil and gas purchaser, which these plaintiffs did not do. And once they did do it, they were paid, and they have continued to be paid since then through very recently.
Now, counsel, I'm interested in your argument concerning the cessation of payment due to the low price of oil and how that relates to the prudent operator standard. Could you elaborate for me?
Certainly. The issue here is when the price of oil in 2020 was for a significant amount of time negative, you had to pay somebody to take your oil. And the reason is because the world was shut down, nobody was using oil, and all the tank storage was full. So I don't think that the law requires the oil and gas operator to be prudent by paying somebody to come take their oil. The Collins case, which is cited in our brief, says that low prices justify not producing and selling oil during the times of low prices. We were in fact producing the oil, we just weren't selling it.
But what proof do you have of that?
We have affidavits from the two pumpers that pump this lease that they're out there every single day, and they filed affidavits in this case that says, yes, this unit was continuing to be produced throughout 2020, we just weren't selling oil.
But there weren't any records to quantify that or support
We
that.
don't have the pumper records on that, frankly, Your Honor, but I mean, we do have the human beings that were doing it who have signed an affidavit under oath saying it was happening.
But then to controvert that, I think Appalachia cited some Cali County records and then the Kansas Geological Surveys. And so their calculation was, I believe, like it was producing 0.65 barrels per day. How do you respond to that evidence?
Well, I respond to that evidence by saying we have the evidence from what Coffeyville Resources was paying us. I can't tell you how they came up with their calculation because I frankly don't think it's correct.
And I'm going to stop you there. So we've talked a lot about production. I want to shift for a second to exploration. So if I understand, under Kansas law, there's an implied duty in every oil and gas lease to explore or develop. And so, they are citing an affidavit from your CEO where he is saying they have no additional plans to drill or explore wells on the Folsom unit or the Kelly lease. Is that correct?
He said they didn't have any current plans to drill. He didn't say that they never intended to drill again. They are operating prudently, producing oil, and as the production and as the economics dictate, they will drill additional wells. So the plaintiffs relied heavily on a affidavit from Mr. McGowan, who claims to be an oil and gas operator in Kansas, and he claims to operate a company called McGowan Oil Company, LLC. The problem with that affidavit is McGowan Oil Company, LLC is not a licensed operator in Kansas. And so it's false on its face. There is another company, there's a McGowan Family Partnership that is an oil and gas operator. The difference is that he didn't cite that, first of all. And second of all, that company has produced about 1,000 barrels of oil since 2014. LAWCO has produced 247,000 barrels of oil over that same period of time.
But not on this lease.
But not on this lease, but they have continued to produce this lease, and they show a profit of $50,000 over the period of time that is relevant in this lawsuit. $50,000 meets the standards of paying quantities, and a prudent operator in Kansas, if you make money, in spite of what the trial court found, just making money does not require you to continue to drill more wells. It is when you prudently can drill wells for both your own benefit and for the benefit of the lessee is when you should drill more
What
wells.
evidence is there that withholding the exploration and further drilling is prudent in this particular case? Was that ever addressed in those affidavits?
The prudence is that that LAWCO has spent, frankly, several $1 million drilling these wells, and they are entitled to have some hope of recovering their money. And they have also spent a lot of money evaluating this geophysically, which is covered in the affidavit. And they don't believe that there is a hot drilling location on the Kelly's property that is something that they want to drill right now.
But that was shared with the district court?
It
All of
was
that
shared with the district court. That affidavit is before the district court.
The conclusory affidavit, but the exploration logs were not part of the record. I
Well,
didn't
they
see
did
it.
not provide a copy of the seismic itself, Your Honor. I mean, it is proprietary to LAWCO, and I mean, frankly, it is.
So you can say one thing and it's secret, so we can't read it, but you can say that's what it is.
Well,
How's that any different than McGowan saying, well, I'm a producer?
well, it's different because unless you are a petroleum engineer or a geologist, I don't know if we gave you the seismic, it would necessarily mean anything to you, frankly. And it wasn't relevant to show you the actual seismic readings itself. I
Okay.
mean, that's a geophysical log.
Was that your choice to not present that?
It wasn't my choice necessarily. It just didn't seem like it was necessary. The plaintiffs presented no evidence on any of the factors required by the law that require further development. They did not analyze anything or provide any evidence about any of that beyond the fact that, well, you didn't drill any wells on the Kelly lease. And there is a number of Kansas cases that say, from this court, in fact, that say, just saying you didn't drill a well out here is not enough.
Thank you.
Any further questions? Thank you.
Thank you.
And we will give you some extra time. Okay. You may proceed.
I won't belabor the facts here, but I do want to stress that this lease, again, this lease has been in effect for over 10 years. It had been in effect for over 10 years at the time the lawsuit was filed. And there had been no wells drilled anywhere on any part of the lease during that period of time.
But that's okay, isn't it, since the Folsom unit was included in part of that
That
legally? I mean, just as a matter of law, nothing per se is illegal about that fact, correct?
actually there is, because to the extent that LAWCO contends that production from the Folsom unit was profitable, they had an affirmative duty to explore and develop the remaining acres in the Kelly lease.
That
So
obligation is to the entire unit, not just the Kelly lease, but that obligation is to the
Absolutely.
entire unit, right?
absolutely, and we may be before you on that at a future date, but
And
Um,
how many acres were pulled into the unit and how many remained in the Kelly Trust?
there were 1,462 acres in the original lease, 160 of which were included in the unit. And there's 1,322 acres that were untouched by LAWCO, at least as far as drilling and actual well exploration is concerned.
You mentioned profitability, but don't you have a dispute between the facts here as to what amounts should be included in costs so that you determine profitability? It seems like the parties, talk about, well, do we have to include this or the insurance costs and the overhead and things like that?
Correct. There was some discussion about the fact that insurance, for instance, is not a cost to LAWCO because they're self-insured. There was some debate about the fuel costs associated with operating the one well on the Folsom lease that was producing, because LAWCO contends that they didn't have to buy propane to run that well. They could get they used the natural gas produced from the well, but that wasn't consistent. I mean, at some points they used the natural gas from the well, and at other points they did not. So it's hard to tell, and it's hard to really to believe that the well, if it was capable of producing sufficient gas to run the operation, that it did do so over the course of its production. But in any event, that was a debate. There was another debate about the fact that during the year 2020, LACO showed expenses for a pumper to maintain the lease for only 2 months of that year, and indicating that the lease was unattended for the remaining 10 months of that year.
Council, I've got a question about 2020.
Yes, sir.
According to what I read, there was no production
Correct.
on the lease, the unit. I'm going to say the unit
Right.
for the year 2020.
There was,
Although
there were no sales.
there are no sales. That's probably more accurate.
Right.
There was some sort of production put in large tanks, but nothing was sold.
Correct.
Now, I think all of this is governed, is it not, by the prudent operator standard? If the price of oil is so low that you can't make a profit, why would it be prudent for an operator to sell at a loss?
I don't think it's necessary for the operator to sell at a loss, but it is necessary for the operator to consult with the lessor and explain to them exactly why they're not producing the well that holds their property.
Is there anything in the lease that requires this advisory to consult with them? Because the operator of the lease is the operator of the lease, and the leaseholder is the leaseholder, and one doesn't do the other.
No, but it is a cooperative venture insofar as the lessor is allowing the use of the exploration and development of their minerals, and the lessee is operating to fulfill that obligation under the lease.
It seems to me that this is just the inverse of the old saying, a rising tide lifts all boats. Well, it seems to me the sinking tide drops all boats, and you're both in the same. There's no reason to have production if it's not going to be sold at a profit, correct?
I don't know that there's any black letter law that establishes that. I think that what the law says is that the operator has to sell
Sometimes
production.
you have to have common sense, don't you? I mean,
Okay, all right.
you don't do business to lose,
I'll grant you that.
correct?
I think that there is justification for suspending operations or curtailing them or limiting the operations to the extent it's necessary to avoid a loss.
I'm more interested in the affidavits, because we've heard comments disparaging an affidavit that's used, and interested in the exploration. These seismic, have you seen these seismic
No,
studies?
I've trusted the word of the affidavit on that fact, Your Honor.
Has there been exploration on,
So far as they say,
Police?
yeah, they say there has been, and I'm not going to dispute that. I think that's fine. The fact is that on the 1,462 acres, there's been no drilling. And if they're not willing to, if the exploration doesn't result in drilling, then the lease ought to be released. And if they're not gonna develop the lease because of low prices or because of whatever, because it's too expensive to do so, or because their exploration doesn't justify it, it doesn't matter. If they're not gonna use the lease for its intended purpose, they need to let it go.
isn't there a fundamental principle in oil and gas law in Kansas that the leaseholder has a right to have the lease developed?
The leaseholder being the lessor,
Yes.
lessee.
The lessor.
Lessor, absolutely. In fact, that's KSA 55-223. And the consequence of non-development under KSA 55-226 is there's authority for termination of the oil and gas lease if you breach that covenant.
It seems to me that in this case, when we look at it, we're seeing a battle of the affidavits. And that's not normally how we grant a summary judgment motion. We're looking at the facts and controverted facts and comparing them to see if there's a genuine issue of material fact
Right.
about these things. And, you know, you guys have opposing affidavits with contradictory conclusions. Why shouldn't we just throw up our hands and say, well, there are facts here that are debatable. We should let it go to trial.
Go to trial. Because the facts Your Honor, the facts are such that they are compellingly in favor of the plaintiffs in this case, of the appellees. And that's based upon, as far as the absence of production from the Folsom unit is concerned, that's based upon the sales that occurred after the lease failed to sell anything during the year 2020. In October of 2021, after there'd been another additional 10 months of production, it only sold some 500 barrels of oil. So if there had been all this production from the lease, it wasn't evidenced by any sales. And it certainly wasn't evidenced by any production records Lawco keeps because they didn't have any. So, and it's incumbent upon the operator, the appellant in this case, to produce records necessary to show that that lease was producing, and they didn't do it. The only thing they had to show for it is some sales during the following year, and most of which consisted of these tank bottoms or oil that was sold to the reclaimer that wasn't suitable for sale to their standard
But
purchaser.
they dispute that as well. They say it's not tank bottoms.
Fine. Even if you include that oil in the calculation of profitability, it's that unit was still unprofitable for the year from the end of 2019 all the way through till 2022.
And just so I understand, so when these these competing motions were filed, as far as the discovery process, it was only paper discovery that had been exchanged, no depositions
deposition.
of the affiance. Is that correct?
No, then there was really, we didn't see any reason for it because we felt that like the affidavits and the paper discovery were sufficient to establish the plaintiff's case in this matter.
And then the other question I had pertains to the attorney fee argument. So, as I understand your claims, they are all based on breaches of implied duties. Is it possible under the statute to be awarded attorney fees for a breach of an implied duty under a lease?
You're correct, with the exception of breach of the abandonment clause of the oil and gas lease, which requires continuous production after the end of the continuous profitable production after the end of the primary term.
But does the habendum clause create that duty, or does it just say this is means for termination of the lease? Is it an independent duty you must keep producing
Well,
bank quantities, or is it just that the lease will fail if you don't?
I think that's a distinction without a difference. I mean, if you don't have production, then the lease automatically expires.
Right, so it's talking about termination of the lease.
Correct. And if it's going to expire or has expired, actually, if it's going to expire, it's incumbent upon the operator, the lessee, to restore that production within a reasonable time. Or to take steps to restore that production. And they didn't do it. In fact, they committed to not drilling any additional wells.
But you're not arguing they have an intent to abandon the lease.
I think if the lease doesn't produce in commercial quantities for a period in excess of 1 year during the year 2020, and thereafter until the sale in October of 2021, I don't know that the intent really has anything to do with it. It's a matter of did they or did they not produce in accordance with the requirements of the habendum clause.
Do you have further points you'd like to make?
Well, I had several, but I think what this comes down to, as far as the production is concerned, is proof of that production. And we have affidavits from some of Lawco's employees that's where they said they were around the unit, around the producing well during the year 2020, and it was continuously producing. And if so, that needs to be quantified, and it never was. There are cases we cite the Eichmann versus Lavelle Resources case, and as do they, for, excuse me, for competing obligations. But there's another case that is important. I'm going to quote to you from the ruling of the Supreme Court in USD 323 versus CWD Investments. If a moving party shows the absence of facts to support an essential element of the non-moving party's claim, the non-moving party has the affirmative duty to come forward with facts to support its claim, although it is not required to prove its case. In this case, they didn't come up with the facts necessarily to establish. They had the burden of proving that well produced, that the wells on the unit produced during that year, and perhaps during the 10 months following, and they didn't do it. They couldn't do it.
It seems to me that your attack on this is broader than just non-payment.
It is. It is.
It's the
there's-
failure to, also the failure to explore and develop.
There's also, correct. If the Folsom unit is profitable, then there is an obligation to further develop and explore the remainder of the Kelly Trust lease, and they didn't do it. If the well in the Folsom unit is non-profitable, that obligation goes away, but then so does the Kelly lease. There's another aspect to this too that might be overlooked, but it's important, and that is, in addition to the obligation to explore and develop, there's the obligation to market the production from the lease. And as you said, there may not be that obligation if it's could only be sold at a loss, but there still is an obligation to confer with the lessors to establish whether or not that sale or the absence of sales is going to upset the validity of the lease. There is also a requirement implied under oil and gas leases in Kansas that the not only does the production have to be marketed, but that the that the sale of the excuse me, that the lessee, the operator lease, has to prevent that lease from drainage from offsetting production.
There wasn't any trial on that below, though, at the trial court level, was there?
Well, that was certainly pled as part of our as part of our summary
Are there
judgment.
facts admitted in the facts to the district court on drainage, the drainage?
Yes, absolutely, because there's only one, perhaps two wells producing on the Folsom unit. All of the acreage to the north along a border of 1 mile belongs in the Kelly lease. And there was no drilling on the Kelly acreage to the north of the unit to protect against drainage from the balance of the Kelly lease to the north, where the royalty would have been 4 times what it was from the Folsom unit.
But
Just due to the size of it,
I'm sorry?
just due to the size of it, it would be larger royalty, right?
It'd be larger royalty because it wasn't unitized. So there was no acreage attribution associated with the royalty calculations
Or the expenses.
or the expenses. That's right. Anyway, those are other aspects of this. Again, the requirement to market the production or the requirement to drill offsetting wells to prevent drainage only pertains or obtains when there's profitable production on the Folsom unit in this case. And if that's the case, then they breach those obligations. If that's not the case, and the Folsom unit was not operating at a profit, there is no obligation to market. There is no obligation to drill offsetting wells on the balance of the Kelly lease. But by the same token, the Kelly lease expires because it's not able to produce in commercial quantities. So
Any other questions? Thank you.
Thank you.
Council, you have 5 minutes for rebuttal.
Thank you, Your Honor. Well, I just want to address a few questions. First of all, there is no obligation on behalf of a lessee to consult with a lessor in this lease or frankly, probably in any other lease. The lessee operates the lease and pays royalty to the lessor, and that's it. They don't have to go tell them what the seismic says or whether they're going to drill another well or not, or any of those sort of things. And in fact, I would be surprised if any operator does so.
There's no duty to consult,
There is no such duty to consult.
either implied in law or by contract in the lease.
Correct, Your Honor. There is no case law that says that, and there's no contractual language in this lease or any other lease I'm aware of that says it.
Tell
So,
me, is this an old Form 88 lease?
I have it here. Hold on a second, Your Honor. I don't think it is.
All right. It's nostalgia on my part.
Yes,
Beg
no,
my-
I understand.
Your pardon, but
It is not a Form 88, Your
All right.
Honor. I think it's a paid up lease form.
you know the form I'm talking
I
about.
know exactly what you're talking about. So that just isn't the case. Secondly, the law in Kansas under Reese versus Lawson Prey versus Premier Petroleum, all of those cases say you don't go and look at one little narrow time period when the markets are in bad condition and decide, okay, well, you didn't produce for this little slot right here and paying quantities, so therefore your lease is terminated, when your lease is otherwise very profitable. And the trial judge found that the appropriate period of time to determine profitability was from 2016 to 2022. And he also determined that it paid in paying quantities during that time period. And for the plaintiffs to now assert that, oh, we ought to just look at 2020 when the world was shut down is not the law in Kansas, and it frankly shouldn't be, because there won't be very many leases survive in this state if that becomes the law.
Let me stop you for a second. I mean, just getting back to basics, these were summary judgment motions. You know, an obstacle to summary judgment is a dispute of a genuine material fact. Don't we have that in this situation? I mean, we've got competing affidavits, competing data. I mean, why was it appropriate for the district court judge to decide this case?
I believe, Your Honor, that the reason it was appropriate is because, and this is an important fact, you'd asked about a minute ago, there was no discovery conducted by the plaintiffs whatsoever. And the plaintiffs are given the burden of proof, just like every plaintiff. They're given the burden of proof as plaintiffs, first of all. Second of all, the Eichmann case, the Rockhold case, the Staley case, all specifically require them to prove you're not producing in paying quantities, you're not drilling additional wells, you're not meeting your duty as a lessee. They have no facts about that at all, and none exist, Your Honor. The information that was supplied by the defendant Lawco is the only information that is out there.
But I think there's a difference between saying a fact is disputed or we win because the facts are not in dispute, but the facts are in our favor. So
Well, I
which
think-
of those do you believe is true for your client?
I think that the facts are in our favor and we should win because we've shown and the judge has found that we are producing in paying quantities. We've also shown that they have not met their burden of proof to show that we ought to be out there drilling additional wells. The trial court, at the summary judgment hearing, Mr. Rose tried to advance the argument that the unit was draining the Kelly lease, which is part of the unit. That was not pled. There was no facts about that, and the trial judge refused to even hear that argument. And I mean, I've never heard of such a thing. You can't have drainage within a unit. It isn't a thing. So
There's acreage, Kelly acreage that's not in the unit because it's not even in the lease.
but it's within the lease and it's held, that entire lease is held by production. And so
Yeah, but
if
that's
I have,
160 acres, isn't it? Or 160?
right, but if I have production on 160 acre quarter section, Do I have a claim that, well, you're draining my other quarter section that's in the same lease? No, there's no such law like that ever.
Let me back up to the exploration issue. So, I mean, it's a small section of what the Kellys own that is in the unit, and then the rest of it they hold separately in this trust. So what is your duty to explore the acreage that is not in the unit?
The duty to explore I mean, we have some duty to explore, agree. As the affidavits indicate, and we've talked about previously, Lawco has shot seismic. They've drilled a number of wells where they believe that seismic was effective, and they've established production. The seismic doesn't indicate that the rest of that acreage is acreage that they are currently wanting to drill. As time develops, other drilling occurs, they get production information from the wells they have. Leases get developed over time because you're looking at your work as my father always said, my father was a geologist, your work is a mile away from you. And so it's pretty hard to know what's going on down there until you spend some time. And that's why seismic exists, is because it's an ability to go look down there and see what's going on. They've done that, and they've done it over a wider area than just the Kelly lease.
But that's not in our record.
It is in your record, Your Honor.
Well, your statements are that it exists,
It-
but those records don't exist, the seismic.
We
They-
did not
they-
provide
not in
the
our
actual seismic. You're
Yeah,
right.
They're not in our record.
The actual seismic itself is not in the record.
And you say you've done it over a wider area than the Kelly lease. Do you mean wider than the Folsom unit?
Wider than the Folsom unit and wider than the Kelly lease, clear into northern Oklahoma, as I understand it.
It's all connected,
It's all connected.
underground.
Any further questions?
Questions?
No.
Thank you. Thank you both for your arguments today. This matter is taken under advisement. We know how important it is to get you a timely decision, and we will get that done as soon as possible. We'll pause for a moment to let these attorneys clear out and our next case get settled as we will appear. Thank you. Thank you all.
Thank you.
Thank you. Good morning. Are we missing an attorney? There we go.
Yes.
This should be the Moliere case. Perfect. Good morning. We will call this case. This is State of Kansas, Appalachia v. Antoine Moliere, appellant. Case number 128223 from Lyon County. Will counsel for the appellant please state your appearance?
Antoine Moliere appears through counsel Jacob Nowak of the Appellate Defender Office. If it's all right at this time, may I please reserve 3 minutes of my time for rebuttal?
Granted, 3 minutes. And for the appellee,
May it please the court, your honors, State of Kansas appears by Ashley McGee, Assistant Lyon County Attorney.
let me get the spelling of your last name because you are a different name than what appears on my docket. What is your last name?
McGee. McGee.
And is G capitalized?
Yes.
Okay. Ashley McGee. And your bar number. And your bar number, please.
27911.
All right, very good. So 3 minutes for rebuttal and the appellant may proceed.
May it please the court? Trials involving young children often have a certain tension in them because there is a natural tendency for people to want to make these proceedings as easy as possible on the children witnesses, but that has to be balanced against the defendant's constitutional right to a fair trial. And one of the reasons we trust jury verdicts as much as we do is because we afford defendants the meaningful opportunity to test the allegations against them through the crucible of cross-examination, which is particularly important in cases involving child witnesses because there's oftentimes very little significant evidence of the criminal activity other than the testimony of the children for a variety of reasons, which makes it incumbent for defense attorneys to be able to have a meaningful opportunity to form that reasonable doubt through the cross-examination of these child witnesses. But can we say in this case that Mr. Moliere was given that reasonable opportunity when one of the children at issue couldn't testify without her mother sitting right beside and alleged coach sitting right beside her during her testimony?
Was she beside her or sort of back behind her?
My understanding it was is beside, maybe a little bit behind to the right. Obviously, we can get a diagram in the record, but that they described it as behind, so it wouldn't be necessarily in the child's field of vision.
Right.
And then where the other child couldn't maintain a distinction between reality and their imagination for the 20 or so minutes while they were on the stand.
But was there any real impediment to cross-examination?
I think I think to both children, yes, there is. I'll stick with LM for for TM, the boy, it's a little bit more straightforward in that it's really tough to cross-examine someone when they've slipped into that imagination and all of their responses to defense counsel about how or why they know what happened is, I'm a robot, I can launch imaginary drones, I can scan through walls. There's not much that you can reveal about what that child actually saw or knows from that type of examination.
That was apparent to the jury as well, correct?
That the child was slipped into an imagination. Yeah, I mean, I don't think it's necessarily apparent precisely.
How does that impair your ability to cross-examine? I mean, a witness is a witness. I mean, how they perform is evaluated by the jury. What was it that was impeding a cross-examination?
Well, the problem with the child witnesses in these cases is that regardless of how they perform, the state's still going to be able to present the CAC interview. And the juries are going to be able to rely, at least in part, on that. So if the child isn't able to meaningfully participate in the trial process, then if their testimony isn't going to be considered strongly by the jury one way or the other because they say, it's a kid, they were just imagining things, then that CAC interview becomes all the jury relies upon. And that's pretty much a step away from trial by affidavit because there's no way for the defense attorney to meaningfully contest the statements made there.
And there's no easy way for the state to prove its case if you've got a child witness like that. I mean, you have what you have, isn't it? I mean,
I've seen it be pretty easily proven through the CAC interviews when the children just get up on the stand and say they don't remember anything that happened. And that's sort of a backdrop of why TM's testimony is problematic because we weren't able to meaningfully engage with him while he was up on the stand. As it pertains to LM and how the mother's sitting next to her impeded cross-examination, I think you could ask pretty much any CAC interviewer, Saint Art nurse, or certainly any defense attorney who's ever done juvenile defense work. And they'll tell you that if you want to get the full story from a child, you need to speak with them outside the presence of their parent because more often than not with these kids, obviously the allegation in this case is a full coaching, but more often than not, these kids, when they're speaking to their parents about events, they're going to at least omit, if not fib, about certain circumstances related to the event because they think that their parent might be disappointed or upset if they learned about those specific circumstances. It might not have all that much to do with the actual allegation, but it colors the events and is important for the jury to hear. Well, if the kid who's been talking with their parent or about the event for, the year leading up to trial has been omitting those certain circumstances and events, they aren't going to all of a sudden become forthright at trial if their parent is sitting right next to them or even in the gallery looking at them. And to that point,
Let me stop you. So we're talking in generalities, so let's focus on the facts of this case. So in this case, the motion for a support person was granted, but there were strict rules. Are you alleging that the support person violated any of the rules that were set by the district court?
I don't really know what the strict rules were. I think that the state had made a comment that they had
Well,
them not to interact, and
it was where the support person could sit, could not move, could not comment, could not react. I mean, they're
Sure.
all in the pretrial order, very strict rules on the participation. So I guess I'm struggling to see how the court abused its discretion in allowing the support person
sure.
if this person didn't violate any of those rules and simply sat there. How is that an abuse of discretion?
It's because they didn't abide by the procedure in Dayhuff and conduct the investigation that would have been necessary before allowing the person to sit as an emotional support person. You're correct. There was no evidently active coaching that was taking place or violation of those rules during the jury trial itself. Our contention is that the mere presence of the mother would have continued to produce this coach statement, which is what was alleged below.
But in Dayhuff, I mean, that case was an active coaching situation where the
Sure.
court had to stop and get to the bottom of it.
Mhm.
So in this situation, why would the district court think it needed to stop and investigate if there was no evidence of active coaching?
Because you had a formal allegation of coaching by an officer of the court. And I don't think that necessarily Dayhuff is drawing a line that it's only circumstances that are taking place inside of the courtroom. For instance, if a defense investigator saw active coaching going on in the hallway right before a witness got on the stand, surely that would merit an investigation by the district court.
So is it just the inconsistencies of statements that you think triggers an what is it that triggers the investigation?
Is it
then?
just the fact it's the child's mother?
It's a part of it's the child's mother. It's the formal allegation by the defense attorney. They did support it with the inconsistencies, and so to that end, I think it is very similar to a justifiable dissatisfaction claim, in that the court, not defense counsel, is going to be in the best position available to conduct the investigation, because the people who know whether or not the coaching took place is going to be the alleged coach, the mother, and the witness.
Is there any
And
case law linking those two very separate areas of law? I mean, you're talking about when a defendant believes there's a conflict of interest with their attorney. How do we get from there to a judge's duty to investigate coaching?
no, I don't think there's any. I mean, Dayhuff really hasn't been analyzed much in the, at least in published opinions. There are a couple unpublished opinions I did find where the court did conduct a thorough investigation. And then we're in abuse of discretion land, which that's, again, very similar actually to the justifiable dissatisfaction claim. But the reason I think the court needs to be the one that's doing this is because, again, it's going to be the coach and the witness who are going to be the only people who really know what happened. And that's going to limit a defense attorney's ability to actually conduct an investigation into it, because the mother doesn't have to talk to the defense attorney, and they certainly don't have to let their child talk to the defense attorney beforehand. And I do kind of like the process of raising it at trial, for that, because if you, for instance, if you were to notice it up for a hearing and subpoena all these witnesses, assuming it's true, then you're just giving the coach, who has still a measure of control over that child, time and opportunity to coach them for that hearing as well. Well, here's what you need to say when the judge asks you these questions.
I want to
Well,
make sure, go ahead.
sure.
I'm sorry.
Well, the judge looked at the motion, which was raised timely.
Yeah.
And then he looked at the facts, whatever the inconsistencies were that were alleged, facts that this is the mother, and looked at the law and then made a ruling. Why are we not reviewing that for an abuse of discretion?
Because, I mean, because Dayhuff says conduct an investigation. I don't think you can conduct an investigation without talking to the parties that are involved. I mean, any finding, for instance, I don't think the judge actually, from my view, made any findings. But any finding they would have made about coaching wouldn't have been supported by substantial competent evidence, because they didn't talk to the mother. They didn't talk to LM to determine whether or not there was any measure of influence that LM had exerted over her prior to trial or prior to the CAC interview that she gave. That's what you need to do before we can really review any sort of findings the court makes, they have to go through some measure of process.
Is there some authority that you have to make us assured that, yes, in fact, the judge does have to speak to these people individually before they determine?
I cited the
motion.
various cases that talk about the judge's responsibility to actually exercise a discretion and what that requires. Again, we've got the justifiable dissatisfaction claim, which says you have to actually conduct some inquiry. Monclaw talked about how there's no.
I mean, in this
ability-
context of coaching the witness.
Well, I guess I'm relying on Dayhuff because that is the only published case on this matter. And in that case, the court took issue with the fact that the district court didn't produce any sort of investigation during the allegation, and then even took issue with, they waited 7 months, allowed that investigation to come in and conducted it at the sentencing, but they said at that point it was too stale to really be meaningful to determine whether or not there was coaching involved. So to your question, I'm relying on Dayhuff, and to the extent that Dayhuff doesn't extend as far as I'm arguing it does, we're making that argument based on comparable cases that we think.
I want to
Or-
make sure we leave time to talk about TM in
Sure.
his testimony. So I believe you're alleging a Brady violation. Tell us about that.
Yeah, so the NAPU v. Illinois is the state's duty to advise the court and the jury that false testimony was presented. That is a subset of a Brady violation, which takes us out of contemporaneous objection land. We don't have to contemporaneously object to any Brady violations because, I mean, frankly, those are typically, we're looking at the bad acts of the state. And also, most of those are discovered after trial and before sentencing, and that's where they're raised. Now, granted, it wasn't raised in this case, so we're purely discretion on the court of whether it's going to review it. But given the record we have in this case, there's no additional facts that need to be found to determine that that was a false statement.
But you're
And-
not claiming now that it was perjurious statement.
Because I don't need to prove the child's intent, I'm not claiming it was perjurious. I think it probably the state's characterization of it as the child's imagination slipped in
Mhm.
is true, but that's a problem. I mean, we're talking about a trial for a life sentence, and we don't know where this kid's imagination began or end. He says he saw the event one of two ways. Either he's a robot who was able to scan through the wall, or he saw it through a little crack in the door that evidently is still there when the door is completely closed. There's pictures of those doors, and the police didn't identify any crack that exists. So can we really confidently sit here and say that the whole thing wasn't imagined? The product of the mom saying, hey, this is what you saw, and the kid rationalizing it in his head is like, oh, I must have seen it because mom says I saw it. That must mean I have some sort of power to see it.
But doesn't that all just go to his credibility that the jury determines, as with any witness who seemingly tells something that they have a hard time believing?
No, because when the prosecution has a duty to ensure that they're not presenting false or perjured testimony. So when it is apparent that the testimony, and I'm sorry, I do see I'm over time.
And you can answer.
So when it is apparent that the witness, whether child or an adult, has falsified testimony and then they don't correct it when they're challenged on it, the prosecution has some duty to correct that and ensure it's brought to the court's attention.
But the defense counsel kind of take the ball and run with it with this kid. I mean, kind of exploited his testimony to prove a point. Does a prosecutor have a responsibility to stop that?
No, I mean, I think defense counsel was trying to make lemonade out of the lemons that he got. But
Because this came up in his recross, correct?
well, it
If
first
the
came
defense
up during
counsel's question-
redirect. It was the prosecutor asked, how did you know when they were done? And the kid said, I think it was, well, you know how I can launch imaginary drones, I can also scan. And the prosecution goes, okay, no further questions. And then recross started to happen. And then more of then essentially was nothing but robot, and I can scan through walls at that point. But yeah, it's twofold. I mean, obviously defense counsel tried to use it to their advantage, but it needed to be brought to the court's attention because frankly, I mean, there is an issue of whether or not that child was competent to testify at all based on the language of the statute. And so that's what needed to be evaluated.
Thank you.
Thank you for your
You'll still
time.
have your full 3 minutes.
I appreciate it.
Counsel for Applee? You may begin.
May it please the court. This case comes down to semantics. Both issues can be resolved by taking them in the context in which it was given. Issue one, with regard to the district court did independently assess the merits of the motion at the jury trial. The entire discussion of the court supports that it did in fact make an independent review. The court did not simply shut the motion down. The court did not say, I'm not going to hear the motion. In fact, the court allowed both the defendant and the state to have an opportunity to state their positions on the motion. The court took its time in deciding where the mother was going to sit. It determined the age of the witness and whether in going through those non-exhaustive factors of Rochelle, the court did do that. It considered the age of the witness. It allowed both parties the opportunity to suggest an alternative. And in fact, Moliere objected to even an unaffiliated adult sitting next to the witness. The logistics of where the person was seated, the availability of items, the use of child-friendly terminology. Ultimately, the state had filed motions with regard to the child-friendly terminology and child-friendly items, but given LM's position, the comfort item that was going to be sufficient to allow LM to testify was her mother. The state did propose a cautionary instruction and did in fact caution the mother as to what she would do when she sat there. And the record supports that the court took that into consideration. Ultimately, the court's ruling was that he was not going to overrule the prior judge. That comes down to semantics. While he said he was not going to overrule the prior judge, does not mean that he did not take the motion into consideration. And so I think ultimately, when
So
you,
you think there was a judgment on the merit?
correct,
The court considered the arguments and simply, unfortunately, didn't say, he just said not overrule.
that is the state's position, that he did an independent assessment on the merits of the motion and came to the same conclusion that he was going to allow the mother as the support person at the trial.
I want to ask you a question about our rule in something of this nature, because we aren't conducting a trial. We are only looking at a paper record. And of course, this is serious charges, life sentences involved. Ultimately, we have to decide if this was a fair trial. Was this a fair trial?
Absolutely.
Did this mother coach this witness?
There's
Any evidence of that in the record?
no evidence in the record that the mother coached the witness. There was nothing raised at the time of the jury trial. And in fact, Judge Larson, when he agreed to allow the mother to sit there, made a statement that if he were to see any type of coaching behavior, he would have stopped the jury trial and addressed the mother.
Can we rely upon that? Or it seems to me that the defendant is arguing it's the appearance that bolsters the testimony of the child, just the fact, the whole drama. Is that how you understand the argument?
That's how I understand the argument. I do not believe that's sufficient. That is not evidence. The evidence in the case does not support that there was any type of coaching. And in fact, when the defense counsel raised this coaching allegation, he raised it as that's his defense. It was not an officer of the court telling the court that he had evidence before him that he's presenting to the court that coaching was in fact happening and he was aware of it. He was merely passing along that the defense in the case is that these witnesses are coached, and that is the reason why they are saying what they are saying.
We often talk about discretion of the trial court to conduct the trial. Is this not clearly an act of discretion by the trial court?
Absolutely. That is the state's position, that the trial court did in fact utilize its discretion in reviewing not only this motion as to whether the mother could sit with the witness, but he exercised his discretion in determining whether there was any proper coaching allegation before him and whether he had an independent obligation to investigate this raised issue.
Let's stop there. That's a good point, and talk about day huff. So The appellant believes that under DAHA, the district court had an obligation once the idea of coaching was presented to it. So he presented it as an officer of the court, made the district court aware. I think your characterization's a little bit different, that he presented it as his defense, but nonetheless, under DAHA, what duty did the district court have to investigate a claim of coaching?
I don't believe there was an active allegation being presented to the district court at the time. The jury trial had just started and we were taking up the issue of whether the mother could sit with the witness. The court was not being presented with an affirmative allegation that coaching had been occurring in the jury trial before it. I think had the court been presented with this is an ongoing coaching issue, the court may have then been more persuaded to stop and investigate. But given the information and the facts that it had been presented, there had already been testimony at the preliminary hearing. The court had already heard evidence before it, and there was no evidence at that time that there was an ongoing coaching that was occurring.
So it was simply a defense position that had been presented through prior hearings. But at the trial, there was never an objection, Your Honor, coaching nothing was brought to the district court's attention.
That is correct. And so
Okay.
the state's position is at that time, the court, in exercising its discretion, which it did, it heard the arguments of counsel, and at that time ruled that it was not an issue that needed to be addressed at that time, but if the court were to see during the trial any type of coaching behavior, any prompting of the witness, any emotions on behalf of the mother, that the court would stop and intervene at that point.
And the court gave a limiting instruction to the jury about the mother's presence.
Correct. And what's interesting is the children went first. The mother had not testified. So at the time that the children are giving their testimony, the jury does not know who this person is that's sitting with the witness until the mother later testified in the trial. So at the time that TM and LM, which by the way, the mother didn't sit with TM and TM went first, but at the time that the mother then sat with LM, the jury had no clue who she was at that time. And ultimately, with regard to whether the court abused its discretion in allowing the mother, the affiliated person in this case, this is not a one-size-fits-all. I know counsel alluded that children, when they need to speak, they don't speak with their parents present. But actually, the record supports that in order for LM to properly give her testimony, the state had taken that into consideration and learned that in order for LM to testify, she needed her mother to be present. Shifting then to the testimony of TM, again, this comes down to semantics, and ultimately the state's position is going to be that counsel is asking this court to make a factual leap, and what is actually not supported in the evidence. Ultimately, TM's testimony was not to a material fact. And TM did not tie his ability to perceive the incident to his claim that he was half human, half robot. And he did not say that he could scan through walls. The testimony of TM was when asked, how did you know that they were done? And his response was, well, like drones, I can scan. I can scan. It's an analogy. And there's nothing before this court that tells this court exactly what he meant by I can scan. Neither the state nor the defense followed up on how he tied his ability to scan to his ability to perceive the incident that was occurring before him. His statement simply was that I can scan. When he is then later asked by defense counsel on recross, and so the state wants to point out that this was on recross examination. This was the defendant's witness at that time. He asked the question, and he actually asked the question in a manner in which he thought the witness would take as a joke. He took the witness out of reality and into his imagination by asking the question, how much of you is a robot, or can you just do things like a robot can? At that point, the witness didn't answer immediately, and defense counsel said, I'm joking with you. I thought you would laugh at me. And at that point, that's when TM said, well, as a matter of fact, I am half human and half robot. And when they started engaging in this discussion about how robots interact, The defense attorney did not stop and redirect the witness back to reality. The defense attorney did not follow up and ask the witness how he was using his robot abilities to perceive the incident. And in fact, the record actually supports that the witness testified more than once and had told multiple people before testifying in court that he did not use his robot abilities to see the incident, but rather he was looking through a crack in the door. And counsel says that, well, there was no supporting evidence that says he could see through the crack in the door. The witness testimony is evidence, and that is the evidence that is before the court today. There is no further evidence that TM used his robot abilities or scanned through walls. That's not what he said. He said, I am half human and half robot. And I think if you take that statement in the context in which it was given, this was not to a material fact. Counsel cannot make this become a material fact by taking it out of that context and asking this court to do so. That is a speculative inference that he is asking this court to do. And while the court can absolutely make reasonable inferences from the evidence, this is a speculative inference and would not be permissible for this court to do. And I think it also is important to note that while ultimately the state has an independent constitutional obligation as it relates to a duty to correct perjured testimony, this was not perjured testimony. It was not to a material fact.
And let's pause there. How are we defining perjured testimony?
I find this interesting because in the reply brief, counsel alluded that NAPU is the controlling law. It's the Supreme Court law, and NAPU is a 1959 opinion that used the term false. Kansas cases that have taken into consideration NAPU, that have addressed it, use the word perjured. And that is a notable distinction because false takes out intent. Perjured takes intent into consideration. In the Kansas cases, like State v. Betts that was cited in the state's brief, use the word perjured, and Betts specifically cited to NAPU. So Kansas, when adopting NAPU, used the word perjured. A conviction obtained by the introduction of perjured testimony, then the prosecution had the duty to correct what it knew to be perjured. And
by that you mean intentionally,
correct.
there was an intent to deceive.
Beyond just a false statement, the state needed to know that it was both false and that the witness was intending to make a lie to the court and to the jury.
What evidence do we have in this record that we can form the opinion that the child intended to deceive?
Absolutely. It's not what we know. We as adults with reason and science can say TM is not half human, half robot.
Answer my question. What evidence is in the record is there that we can conclude this child intended to deceive?
Absolutely. There's nothing. There's nothing in the record to show that TM knew by saying he's half human, half robot was a lie. That is not in the record. Nobody either followed up on direct examination or cross-examination whether he knew the difference between the truth and a lie as it related to that question. He was specifically asked on cross-examination, what part of you is a robot, or can you just do things that robots can do? He was taken out of reality on cross-examination into his imagination. And what defense counsel thought was going to be a joke, the witness thought it was an opportunity to talk about something fun, because this is hard to talk about.
Can we infer from this record that the child was just playing?
I do not believe, to some extent, when he was prompted to talk about robots, he went with that. But can we infer that he knew that he was talking about a lie and that he knew what he was doing was false and intentionally false? I do not believe so. What did TM know at the time that he made that statement? That's what matters, and that cannot be shown in the record by either side.
Go ahead.
This is categorically a different type of statement than any case examining perjury, correct?
That's correct.
To your knowledge.
That's correct.
And along those same lines, where do we find the requirement that the perjured testimony must be related to a material fact?
Can you ask that again?
So why do we have the requirement that it must be a material fact? So, he's going on and on, but why is it important that his testimony must be related to a material fact to be perjury?
So that was the state's main argument in this case is there's no question it was a false statement. And even if TM didn't know or knew it was a false statement, regardless, his statement was not to a material fact. His statement about being half human, half robot was not to his ability to perceive the incidents as counsel is asking this court to do. He simply made a statement that, and again, it was asked on cross-examination in a playful manner. And so when you take into consideration his prior testimony that he had given and the times that he had spoken prior to even testifying in court, it is clear that he saw this with his eyes through the crack in the door.
Any other questions? Thank you.
Thank you.
The appellant has 3 minutes.
Thank you. Initially, as a matter of record clarification, TM is the first one who brought up being a robot on cross-examination. Defense counsel asked, "You said you can scan?" He says, "Yes." "What does that mean?" TM starts talking about robots.
How old was this child?
What's that?
How old was this
At
child?
the time of trial, I believe TM was 7. I mean, the record will speak for itself, but I'm fairly certain.
7.
Um,
How do we know he wasn't playing?
if he was, that's a problem. If he can't sit down.
That's the difficulty I have with this argument. And I see these and can't see the expression on his face. Did he have a glint in his eye? Was he smiling when he said this? I have raised 2 boys and they said all sorts of things when they were 7 years old.
Sure.
They were playing. Wasn't in a courtroom.
Yeah, no, that's the problem. And we talked, or not, Kansas Supreme Court talked about this in Ray Bowman, is that building trial testimony around live children is a risk. That is a risk the state assumes because they have other options. They can file a sync case, get a protective order, and consider refiling charges when the kid's closer to 10 and can meaningfully participate. But when they assume that risk, they accept the consequences. And the consequences here are the state presented a witness who, by their own admission, cannot sit still and testify truthfully and tell the difference between truth and imagination. That's a problem, and it needed to be corrected below.
But you haven't argued this issue as the court's failure to conduct a competency hearing.
That's correct. That might be an issue available on 1507. I do think for that, there would have needed to be an active objection and a motion for a mistrial from counsel. I raised it the way that it was presented because it is an error that is presentable on direct appeal, and so that is how I've raised it.
I'd like to revisit DAHA for just a second. So when I asked your opposing counsel, she characterized the officer of the court's involvement on the coaching issue as basically saying, this is a defense position we have, not that, Judge, I'm notifying you of active coaching. Do you agree with that characterization?
Oh, not at all. No, this was directly, the defense attorney told the court the presence of the mother, that this mother had coached this child, the presence of the mother would just reinforce what we believe to be a coach statement rather than the truth. It would very likely influence the validity of the testimony.
But there were no observations that they were basing that on. That was their defense position. But I'm saying, was there a point in trial where defense counsel said, Judge, we need you to investigate. We think there's coaching going on?
That's the purpose of the objection. I guess they didn't say the word investigate, but no, we're not. I guess to clarify, we are not worried about there being active coaching going on during the trial. Frankly, I'm less concerned about that as a general matter because the jury actually sees that, and then that impacts the credibility of the witness. What we are worried about is the mother coercing these children into engaging in false testimony in the CAC interview and on the stand. That's what we brought up. That's what needs to be investigated. So I know the state argued that they applied their discretion in conducting the Rochelle factors, but that's conflating the issue. There wasn't a Rochelle error. There was a Dayhuff error. Once coaching is brought up before the court, they have a duty to investigate and ensure 2 things. One, which doesn't really apply in this case, is did the coaching have an impact on how the jury perceived events? The other is, did that witness's testimony become influenced by the individual's actions? That is something the court needs to look into. It's particularly important in these types of cases because children are more susceptible to being influenced by their parents than your average witness.
Did the CAC witness testify to a couple signs of coaching?
Yeah, absolutely. There was, so the CAC interview talked about, there's three major signs of coaching that we look for. Two of them were present in this case, which is inconsistency in the victim. We know that there were, which by the way, this refutes what the state said at the hearing of one recantation. There were 4 times to 4 different witnesses that LM recanted, at least in full or part, her statement. The other is the inability to give sensory details, the things that you would see, feel, hear, or touch during the event. And LM wasn't able to give any of that during the interview with the CAC. Interviewer, in fact, went silent whenever that opportunity presented itself. The other instances of coaching we can see through TM's testimony. He repeatedly said, and by the way, it's telling that the mother wasn't sitting next to TM when he was saying this, that he'd forgotten everything, but that someone helped him remember. And it was his mother who helped him remember it. And his mother told him what he needed to testify at trial. That's coaching. TM, or Ellen's mother scolding her when she recanted. That's coaching. That's the type of evidence that would have been uncovered had the court followed procedure. And at that point, then we could get into abuse of discretion land. Right now, we're at error of law. Unless there are outstanding questions, I would ask this court to reverse, and thank you for your time.
Thank you. Thank you both for your arguments today. We will take this matter under advisement and issue a decision just as quickly as possible. Thank you. So that concludes our morning docket. We will resume our afternoon hearings at 1:30 p.m. We are in recess. Thank you.